Joint ventures in Vietnam are a common entry strategy for foreign investors seeking local market access, regulatory support, and operational efficiency. At the beginning, these partnerships are built on trust, aligned interests, and shared goals. However, as the joint venture evolves, a critical question often emerges. How do you protect your confidential information and prevent your partner from becoming your competitor? This is where confidentiality and non-compete agreements in Vietnam become essential, but also legally complex. In a joint venture, both parties contribute value. For foreign investors, this often includes technology, proprietary processes, business models, client networks, or strategic know-how. Once this information is shared, control becomes more difficult. Without a properly structured confidentiality agreement in Vietnam, your intellectual assets may be exposed. And if the relationship changes, the risk of misuse increases significantly. Many investors assume that signing a standard NDA is sufficient. In reality, joint ventures require a more sophisticated approach. A generic NDA may not adequately cover the scope, duration, or specific nature of information exchanged in a long-term business relationship. More importantly, if the NDA is not aligned with the joint venture agreement and Vietnamese law, enforcement may be limited. Confidentiality in joint ventures is not just a clause, it must be embedded in the overall legal structure. Unlike employment relationships, non-compete agreements in joint ventures fall under commercial law rather than labor law. This provides more flexibility, but also requires careful drafting. A non-compete clause between joint venture partners can restrict certain competitive activities during and after the partnership. However, if the restriction is too broad or lacks clear justification, it may still be challenged. The key is to define what constitutes competition and ensure the restriction is proportionate to the legitimate interests being protected. One of the most significant risks in joint ventures in Vietnam is that a local partner may use the knowledge gained to establish or support a competing business. This may not happen immediately. It may occur after the joint venture stabilizes, or even after it ends. Without enforceable confidentiality and non-compete protections, foreign investors may find themselves competing against their own former partners, using their own transferred expertise. To mitigate these risks, confidentiality provisions must be clearly defined and comprehensive. This includes specifying what information is considered confidential, how it can be used, who has access, and how long the obligation lasts. It is also important to include provisions on data handling, return of information, and remedies in case of breach. In Vietnam, clarity and specificity are key factors in enforceability. For non-compete clauses in joint ventures, the approach should be strategic. The restriction should focus on specific business activities, geographic areas, and timeframes that are directly linked to the joint venture. Overly broad restrictions may weaken enforceability. At the same time, insufficient restrictions may fail to protect your interests. A balanced and well-justified clause is more likely to be recognized under Vietnamese law. Confidentiality and non-compete provisions should not exist in isolation. They should be integrated into the joint venture agreement, shareholder agreements, and related contracts. This creates a consistent legal framework that reinforces your rights. In addition, governance mechanisms such as board control, approval rights, and operational oversight can further reduce risk. Legal protection is strongest when it is supported by structural control. Even with strong agreements, enforcement requires evidence. You must be able to demonstrate that confidential information was misused or that a non-compete obligation was breached. This means implementing internal controls, monitoring information access, and documenting key processes. In Vietnam, the ability to prove your case is just as important as the contract itself. For foreign investors, joint ventures are often a gateway into the Vietnamese market. But without proper legal protection, they can also become a source of long-term risk. Your competitive advantage, your technology, your strategy, your business model, can be replicated if not properly protected. Confidentiality and non-compete agreements in Vietnam are not just legal tools. They are strategic safeguards. At LTS Law, we support foreign investors in structuring joint ventures in Vietnam with a strong focus on protecting confidential information and competitive positioning. We design confidentiality and non-compete frameworks that are aligned with Vietnamese law, tailored to the specific transaction, and practical for enforcement. Our goal is to ensure that your partnership creates value, without exposing your core assets. In any joint venture, information must be shared for the business to grow. But before you share, you must ensure that your legal protections are in place. Because once your know-how is transferred, it cannot be taken back. Visit lts.com.vn to consult with our legal team and structure your joint venture in Vietnam with the protection your investment deserves.